Good afternoon, Jeremy. Welcome.
Hey, Warren. Thank you.
Thanks. Today we're very fortunate to have Jeremy Morley, who's coming live from New York. I am a family lawyer in Los Angeles, California, and I've worked quite a few years with Jeremy on a couple of cases. And Jeremy is an expert in international law. He's a published author. He's written two treatises, one on the Hague Abduction Convention and the other one on international family law. So he's literally the lawyer that wrote the book on international family law. Thank you very much for coming, Jeremy.
Thanks for inviting me, Warren. Great to be here.
So tell me a bit about what you do as an international family lawyer. What does it mean?
For what I do is I basically sort out weird and unusual family law problems concerning international people or international situations. I do a ton of consulting work. So right now with the virus around, everyone's on Zoom. I spend my day Zooming the world with clients all over the place and helping them to figure out where their case belongs, how they should respond to a child custody dispute, where the best place to divorce might be, and fielding all manner and kind of questions between spouses or partners who are in some trouble and need some help sorting out the legal aspects of it.
I'm going to ask a very kind of broad question. I think it's covered in chapter 1 of your book. Is there such a thing as international family law?
Not really. Not really. Family law is very old-fashioned in a way. We say that the world is getting flatter and smaller, and yet family law is local and parochial. So your rules in California are different than our family law rules in New York. And there's from country to country, there's a gigantic variation. There are some international treaties. The most important one is on international child abduction, and so there is international law about that. But apart from that, and apart from treaties concerning international service of process, basically, it's a question of determining whether a case belongs in jurisdiction A, B, or C, and the laws in many of those places apply their own local law, although some civil law countries will choose a different law to apply, but it's always the law of the local state, the local country. So there's very little that is really international law, even though I call myself an international family lawyer.
So that requires you to have contacts and relationships with a lot of foreign lawyers in other jurisdictions, I presume.
So yeah, so I built up a network of lawyers all over the country and all over the world. I'm admitted to practice only in the state of New York, but I have acquired a whole bunch of knowledge about the laws concerning child custody and the economic consequences of divorce over the years. I have to be very cautious. Anything that I say about any jurisdiction's laws other than that of New York is always strictly subject to confirmation with local counsel. And I bring in and collaborate with lawyers such as yourself in California and other lawyers across the country and all over the world. And it's good. We work collaboratively and together in solving these problems.
And I know that we're working on a couple of cases right now, prenuptial agreements, involving cases where the parties have contacts, either property or contacts in several jurisdictions. Now, in one of the cases, for example, without mentioning names, the parties are currently living in California, but that they have property in other parts of the world and contemplating moving to a different country. Why would we, and my earpiece fell out there. It's the first time that's happened. So why would we consult with another attorney in another jurisdiction?
So in a prenup case where the assets and the people are international, somebody needs to be responsible for sorting out the whole thing from an international perspective. So in the case, one of the cases that you and I are working on together, I think there's probably 3 jurisdictions or 4 jurisdictions that we're talking about. One of them may or may not be New York, but it doesn't matter. what I'm doing is bringing in a colleague of mine in one foreign country in South America, you in California, another lawyer in another US state, and so on, and bringing it all together in one package. So what I found when I first started doing this work, Warren, was that, and I went through my own international divorce quite a long time ago, before I really focused on this. There was a debate as to whether our case should be in England, where we're originally from, as you are, or in New York. And I couldn't find any lawyers who were actually going to stick their neck out and opine with qualifications, of course, as to which was the best jurisdiction or the appropriate jurisdiction. So I find that it's very, very hard for lawyers to look at the big picture when there are different jurisdictions involved. And what I do is look at the big picture while collaborating with lawyers in all of the jurisdictions. So talking about international prenups, I did one where my client was a very wealthy Russian gentleman, and we determined that the contacts that he had in the places where he might live were very numerous. And we ended up building a team, especially here because there was quite a lot of assets to protect, of lawyers in a multiplicity of jurisdictions, and there were incredible complications. But we had to make sure that the places where he might live, or she might live in the future, provided as much protection as one could possibly acquire. So I call myself the puppet master, and brought in a whole team of lawyers from all these jurisdictions globally. And we ended up, I think, doing a damn good job with a very satisfied client, and putting together a structure where there's no guarantees, because prenuptial agreements are never guaranteed of enforcement. But I think we did as good as we could do to provide the best chance of enforcement in the various jurisdictions that he said that he might ultimately reside in.
I mean, one of the things that we've spoken a lot about is the enforceability of a prenup in a foreign jurisdiction, given that, for example, California and New York have fairly well-developed bodies of law on prenups, both their interpretation and enforceability. But other countries, and I'm thinking of the UK, it's taken a long time for some of those countries to even recognize that prenup could change their particular regime of family law or matrimonial law.
So England is kind of scary. They're inching their way towards...
Not just COVID.
You know? So I had the pleasure, Warren, a few years ago of working for a client in Florida who then moved to the Isle of Man off the coast of England. It's an independent jurisdiction. And he had a postnuptial agreement, and the enforceability of that was determined by something called the Privy Council in England. And I had the pleasure of actually writing some of the briefs in that case, even though I didn't argue it because I'm not an English lawyer, but we worked with English counsel. And MacLeod versus MacLeod became the first high-level appellate English case that upheld the postnuptial agreement and said that it was not contrary to public policy. So
congratulations.
Those are fun cases, yeah.
Now, I mean, one of the things I've noticed recently, I've actually got a couple of cases where parents want to move back to countries which have very low COVID rates. One particular case where the couple decided to move back to New Zealand, which until recently, you know, it was in the news that they had no cases for about 100 days.
Yeah.
And now they're panicking because they've got 4 coronavirus cases. Imagine California having just 4 coronavirus cases. Anyway, so that creates, that's an unusual situation, but the kind of move away situations we deal with is usually where, you know, one parent wants to move back to another country, or, you know, there's a jurisdictional dispute between, number one, which court has jurisdiction to hear the custody case, and then when they do, what kind of principles are going to be applied. Can you speak to some of the issues those move away cases raise?
Yeah, they raise, they raise legal issues and they raise cultural issues that are sometimes hard to appreciate. So the move away cases are very tough because they're kind of either or cases. Either mum will win or dad will win. And, often the two countries in question are very far apart. So they vary dramatically. So, I do a lot of cases which involve, say, India. What often I have to educate a judge about is that the Indian legal system is not going to support necessarily support visitation back to to California. So if we're talking about a move away from California to India, and the California court wants to ensure that there will be guaranteed access back in California during vacation time for the left behind father, let us say. The challenge there is, well, will the Indian court recognize the California decree? If the lawyers representing the potentially left behind parent in California don't hire an expert witness to provide evidence about the Indian legal system, then the California court is going blind. And it might assume that Indian law and practice is similar to California law and practice, and that's just not the case. So, as you know, we have a uniform child custody law in California and throughout the states. But that's a weird law from an international perspective. Other countries don't have anything like it. And our concept that a California court will have continuing and exclusive jurisdiction when a child is relocated to a foreign country is anathema to just about every foreign jurisdiction. They're not going to subject themselves to California law when a child is living in their country.
So you're saying in that kind of situation, let's say the California court's going to decide the custody issues, whether the child is going to live primarily in India or live in California, could be in New York, somewhere in the US. So you're saying that once the California court makes a decision, then the Indian court is not necessarily going to enforce that decision?
No way, absolutely not. So it might choose to do so. It might well choose not to do so. There's no way to get an enforceable, what we call mirror order from an Indian court. They don't work. And the Indian legal system is slow. It's horrifically slow, and there's a multiplicity of appeals available for somebody who doesn't like the ruling. And the attitude within the Indian society and within the Indian courts about the best interests of children is quite different than the attitude in California. So, a nuclear family as being the context of raising a child, and we consider that to be, typically a great way to raise a child. The Indian Supreme Court in a case from a couple of years ago said, no, the Americans have that strange system of a nuclear family. In India, we have a large embracing family. We have aunties, we have cousins, we have grandparents. We have a much stronger family structure. And so that was one of the reasons in one particular case why the Indian court said, no, we're not, even though the child was taken to India wrongfully, we're not going to send him back to America where he would be subjected to that American way of raising a child. We're going to allow him to stay in the bosom of a wonderful, large Indian family.
That brings up the Hague Convention. So the parents are initially living in the US, and then one of them takes the abducts the child to India. Maybe it starts off as a vacation, but then they decide to stay there longer. Is India, first of all, tell us about the Hague Convention on abduction and how does it work, and what kind of countries does it apply to? Does it apply to every country in the world or just a few?
So right now there are 101 countries that are parties to the Hague Convention. the United States has long been a party to the Hague Convention. It's quite a simple treaty. It's designed to deter international child abduction, and it's designed to provide a quick return of kids who've been taken from their habitual residence to another country without the consent of the left behind parent or somebody who has the right of custody over the children. There are some exceptions to it, but basically the treaty says return the children right away. The country to which the kids have been taken without the consent of the left behind parent should not decide what's best for the children. They should simply return the children quickly. The target date is within 6 weeks, and let the court in the habitual residence make that decision. So 2 days ago, we had a child and a mother at the airport at JFK, and we had succeeded in representing the left behind father in Spain in securing an order that the child must be returned forthwith to Spain. And so that's in process right now. There's a COVID element to that one because of whether airlines will accept passengers in certain circumstances. But anyway, so over 100 countries are parties to the Hague Convention. It began, I think, as kind of a more Western-leaning group of countries. So the European Union, Canada, Australia, US. And it grew from there. And Morocco is now a party to the Hague Convention. Pakistan just has been accepted by the United States as having acceded to the Hague Convention. And there is a lot of pressure on countries that have not yet signed up to do so. So there has been, in the case of India, a ton of pressure on India because India has become has been seen to be a kind of black hole for international child abduction. And it looked as if they were going to sign a couple of years ago, and they backed off. So that was quite disappointing. They decided that it's not fair to many mothers, they said, who are of Indian origin, that they cannot take their kids back home to India if they are of Indian origin. And so it became a political hot potato, and it still is, as a matter of fact. Whereas another hard nut to crack was Japan. So Japan also was a black hole for international child abduction, a safe haven, as we called it. But a few years ago, after a lot of pressure, they did sign up to the Hague Convention, and they are engaged in the process of determining how to apply its rules. That's become quite challenging for them.
Well, Japan's an interesting country, a lot like some of the other East Asian countries. They have a very different perspective on what is the best interest of a child, depending on whether the parents are agreeable or cooperative. And so that can have a profound effect on where the case is heard. I mean, I think you have some personal experience of that, where, say, for a South Korean or Japanese court is deciding on the issue of child custody.
Yeah, so, and if we don't give an American court expert evidence about how it works in Japan, then the American court is going blind and might assume that a court in Japan or if you say in Korea will follow similar approaches to an American court, and nothing could be further from the truth. So there actually is a provision in the Civil Code of Japan that provides that only one parent can have custody of a child. So what could be further from the best interest of a child than to say that automatically it's not possible to have two good parents parenting a child. Only one parent can have custody in Japan. There is a provision that there can be some visitation for the non-custodial parent, but traditionally that has amounted to a few hours a month with some supervision, typically, not overnight. often in a public place. And
E-
certainly,
even if the non-custodial parent is competent, doesn't have any history of sort of drug abuse or any other red flags, they're good parents or good enough parents. You're saying
yeah,
that in those countries, and I know that's true for South Korea as well, that the non-custodial parent might just have a couple of hours a month, and it would be supervised on top of that.
it will most likely only be a couple of hours a month. It will almost certainly not be overnight, and it may well be supervised. So, and there's never been a case that I have seen, and I've researched this at length, where a Japanese court has ever awarded any international visitation.
Do you testify as an expert in those kind of cases as to the foreign jurisdiction and
I
their custody
do.
laws?
I do. I'm looking forward to doing so in California by Zoom on Monday morning. Sorry, Monday afternoon. But yeah, not in the LA area, Warren. So, but yeah, you know, so I testify as an expert witness frequently. I've been admitted as an expert on the international family laws of many, many, many different countries so far. I think well over 30. And my goal is to simply inform the court of how this matter will be treated if the child goes to that foreign country, or if the matter is before the foreign court. And I think that giving that kind of input in many of these international cases is useful and critical.
Have you been qualified as an expert in a case where someone comes to the US and presents a foreign judgment, tries to enforce a foreign judgment? Particularly, I'm thinking of Middle Eastern countries in particular.
Yep. So they're interesting because, you know, as you and I discussed, you know, traditionally, family law in Middle Eastern countries is Sharia law. And Sharia law, you know, assigns decision making based upon arbitrary rules of age and gender and religion. Now, Middle Eastern countries have, in significant part, adopted legislation governing civil status, and some of that legislation is quite advanced and would be quite similar to that with which we're familiar here in the States, and some is not.
Have you ever testified in a case where you've testified that the foreign judgment shouldn't be enforced in the US because it doesn't comply with either fundamental due process or the human rights escape clause?
Yep. So, you know, so the Uniform Child Custody Law says that we basically treat foreign countries as if they were sister states. And sometimes that's great, and sometimes that's absurd. There is a very, very narrow exception, which you call the escape clause, which is that if the child custody law violates fundamental principles of human rights, then the American court need not apply the decisions of that foreign court. So we won a case in Washington State where I was the expert witness concerning the child custody law of Egypt, and I testified similarly in Melbourne, Australia, in a somewhat similar case. I worked on a case concerning the United Arab Emirates in California, in Northern California, and the court ruled that it would be contrary to California public policy to rubber stamp a decision from a court in, I think it was Abu Dhabi. It's either Abu Dhabi or Dubai. I've testified about Lebanon and Jordan and Qatar and Kuwait and several other countries.
I want to ask you a practical question about what steps can a parent legally take, or practically take, I guess, to prevent child abduction or the risk of child abduction?
So, Laura, this is going to sound really goofy, but I'm going to say it anyway. um, in my world, we're dealing with people that are from very different cultures, very typically. You know, a standard case will be that a guy from here has married a woman who came here from over there, wherever over there may be, but let's assume it's very different. So my second wife is Japanese. So Japan is a different planet, totally different culturally. Very interesting, and I love it. And I have a child who is 12, who is bicultural and bilingual. And people ask me all the time, well, do you allow your daughter to go and visit Japan? If your daughter is kept there, you know that you've been staying there, she'll never come back. And so what steps do you take? What provisions do you have to make sure that your child is going to come back? And my answer is, I'm very kind to my wife. And the truth is, that's about it. So, I've had I enjoy telling an American husband, for example, how to treat a Japanese wife and how to put himself in her shoes. Because he brought this woman over from Japan, or she was in college here and he kept her here, and she's from a different world, and he thinks that she should be an American wife, and she's not an American wife. She's a Japanese woman who deserves to have somebody understand her needs and why she's so upset and maybe furious with her Yankee husband who just doesn't get what's ticking her off. And it starts with the most simple baby steps, like, you take your shoes off when you come into your home. I mean, that's just like, you can't go into a Japanese home with your shoes on. It would be the most extreme faux pas. But there's many other things, you're living with your wife, you took her from Tokyo and you brought her, and you're in the suburbs, and you thought this marriage would work with a Japanese, she doesn't drive, does she?
Can I pause you there for 1 second?
Yeah. Yes.
Okay. Sorry about that. A COVID glitch.
No problem. Can I continue jabbering?
No. I mean, I'm fascinated to hear about how you treat your wife. Is she going to be watching this?
Maybe. I better keep it nice, right?
Are you not wearing your shoes right now, then?
I wear slippers. I wouldn't dream of. It would be as if if I came into the house with outdoor shoes on, it would be as if I was married to a religious Jewish woman and brought pork into the house.
Wow. No
different. So often what my job is to actually, maybe I broaden it, but often with many clients, I will talk to them about their situation and try and get them to understand a little bit more about the cultural context. Yeah. Well, but that's one way to prevent a child abduction. It might be the best way is to really try and understand why the other one is upset.
But I think in the cases that we deal with, it's usually there's a fundamental breakdown in the marriage, gets to that point. And then the client comes to see you because they have a concern that, the other spouse might take the child abroad, or the relationships are rocky, and one of them says, I want to go back and think about things for a while to my country and speak to my parents or whatever, and bring the child with me and, clear my mind, as it were. So as a practical matter, what do you do in that kind of situation? You say no, under no circumstances?
The first step is you determine whether you think you can and should get a court order to prevent the child from leaving the country. If you can do so, then you may ask the court to issue a very clear, very simple direction that this child at this date of birth should not leave this country. We have no exit controls in the United States, but we can work with the State Department and put the child's name on the equivalent of the no-fly list. And if an airline ticket is purchased in the name of that child with that date of birth, then all alarm bells will be set off and the child will not leave.
Jeremy, can you talk a bit about that earlier? There's no exit controls. I mean, that's important, isn't it? So if if the parent is going to the airport or is about to go to the airport,
Yeah,
you can't get an order that you can send to the State Department or wherever, and they'll put a flag at all the airports. Is that what you're saying?
you can. So when I say there's no exit controls, nobody is checking as you leave the country, right? There is no official of the United States government who's checking your papers as you leave, or is checking to see whether a child has consent from both parents before the child is taken. You don't get beyond the airline itself, who is checking to make sure that if they take you to a foreign destination, you'll be admitted into that destination, so they don't have to take you back. But if you are able to get a custody order from an American court that expressly states that a particular child shall not leave the United States, then the United States has a program pursuant to which they will put the name of the child on a list that they will work on with the Department of Homeland Security. And it's akin to or a branch of the no-fly list for terrorists. And if an airline ticket is purchased in the name of that child and that date of birth, the airline personnel will immediately see the equivalent of a red flag, and the police will be informed, and that child would not be able to leave the airport. That applies across the country. Doesn't necessarily apply to travel by car into Canada or Mexico, but it might.
So in usually the parent who's trying to get the order will often go to the local abduction unit of the district attorney's office, who will get that order, or they could go to a private attorney like yourself.
Yeah, but you have to prove why it is, why there's a danger.
Another thing we've talked about in the past is we talked about the Condon case and what kind of orders we should get where there is a move away, and the court does allow a move away. Can you speak to that?
Yeah. So the idea of the California court there wanted to make sure that its orders would be followed in a foreign country, and that is something that, in my humble opinion, ain't going to happen. It's not possible. So the Condon court asked for a financial bond to be filed by the taking parent, and asked for a mirror order to be obtained in the foreign country. So a bond, in my opinion, rarely works because it's never punitive enough. It's never the taking parent's last dollar. If a bond, for example, is in the sum of, I don't know, $100,000, that's a big number, then I think the attitude of a parent who wants to take their child overseas is going to be, wow, is that all it costs to buy a kid? $100,000? I'll do that. With respect to a mirror order, you can get a mirror order from some foreign countries, but conditions about kids are always changing. So every custody order is subject to modification based upon changed circumstances. What is more changeable than when a child is sent overseas and now is in a whole new school, a new city, and a new environment, and everything is new. And so it would be normal for a foreign court to take jurisdiction and take credence of the new facts, the new circumstances, and feel that it is perfectly justified in ignoring the California order and making a new order to consistent with its determination of what the best interest of the child is.
How long does that usually take? I mean, the California court or the New York court makes an order, and they say, we're going to reserve jurisdiction. So they anticipate that California will retain jurisdiction, but after a while, the kid's living in this other country. How long will it take before another country says, no, now that country is the child's home state, we're going to make decisions about custody? Is there a period of time? Or
there's one analogy that I think is appropriate. Within the European Union, there are rules about this, and the European Union rules are that the um, the first country's custody order will stay in effect in the new country for 4 months.
Just 4 months.
It. That's it. So within the European Union, the United States is not a party to the European Union regulation, but why would a European court not feel that where changes have occurred in the well-being of the child, that it has jurisdiction after 4 months or so? I think when a child is in a new school and settled there, then one has to expect that there may well be a foreign court that will take jurisdiction and make a new decision. And while the California court may contend, and will presumably contend, that it has continuing exclusive jurisdiction, that's not going to deter the foreign court in doing what it must do under its law, which is to protect children who are habitually resident in its jurisdiction.
Interesting. Well, how has COVID affected your practice? Kind of curious. Not just in terms of like I can say that you're possibly a home office now.
I'm in my home office, and I enjoy it because for me, talking to you is if right now we're on other sides of one continent, but it's like we're next door to each other in a way, and I can do the same thing with people anywhere and everywhere. So I like that. The challenge that I have is the courts in New York are not up to speed. They're far beyond that. They've not adapted well. They're doing conferences. They're not doing trials. So I have a hate case where we are trying to put the case on a front burner, and the judge is not prepared to do that because of COVID world, I think, and so there are a few trials that are taking place in New York. Many people are using COVID as an excuse to not go back to their home country with a child, or to the country where the child was living. Figuring out what the rules are about COVID and whether kids are going to be allowed in or not allowed in to particular foreign countries is challenging because these rules are changing all the time. So we're up in appeal courts quite often where people are asking for COVID delays, and I think in general on the appellate level in my world, countries the appeal courts here are not allowing COVID too much to act as a reason why children should not be returned.
But have you found any courts actually considering COVID or the rates in another country compared to the US as a factor in a move away? I mean, for example, if someone was to say to me, one parent says, I want to go back and lead a normal life in New Zealand or, Singapore. And let's say, it's a toss up. There's a lot of factors on both sides. It would appear to me that COVID or the lack thereof would be a valid reason.
So I've had a lot of discussions about that with courts, but they've not made rulings really evaluating the extent of the risk in any detail. But I've expressed recently significant concern that if, for example, we allow a child to visit a certain foreign country, then will the child be allowed to come back to the United States? And the rest of the world knows that the United States has done a horrible job in not protecting the population against COVID. And they know that the foreign countries are kind of gleeful about the American collapse of its protection system. So I'm concerned that courts overseas will use COVID as a reason not to return children to America.
And not only to return children, but where there's a case where a court has to decide which country the child should live in, based on the best interest analysis. I mean, if it's a country where the schools are open, there's no cases, you can live a fairly normal life, there's no quarantines. I guess it depends how long this goes on for, but...
but it's a temporary, I think we're still hoping that this is purely temporary and that, the magical vaccine is going to emerge and that we're going to get back to a more normal environment.
Yeah.
If this drags on, then I think those kind of arguments will be even more powerful.
Well, it's been a real pleasure talking to you, and hope to get to talk to you and see you again one day when this pandemic is all over.
We could zoom along, but thank you so much for inviting me. It's been a pleasure, and I always enjoy working with you. Thank you, Warren. Okay,
so I'm just going to give my details. Warren Shiell. My website is www.la-familylaw.com. Our number is 310-247-9913. Jeremy, you have a fantastic website because I visit it quite often to learn about other countries' jurisdictions.
So I'm at www.international-divorce.com, 212-372-3425. Thanks.
Over and out. Thank you, Jeremy.
Okay.
Yes.